Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. It is Tuesday, post-Christmas. Hope you had a nice holiday with your family. Today, we're talking about adverse possession claims. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. We are on Facebook, and we are on YouTube. On YouTube, it is at NREM Podcast. That's at NREM Podcast. Make sure to go there. Make sure to subscribe. We'd really appreciate it. With that, we're going to go to Sean. Give us our legal update.
Thanks, Andy. So today I want to talk about not adverse, that's our topic for today. I want to talk about operating agreements, what they are and when you need them. So an operating agreement is a document that is prepared that governs the ownership and operations of limited liability companies. So they're not to be used for corporations. Corporations, if you're going to have something similar to that in the corporation realm, it's going to be a shareholder agreement or bylaws. But for limited liability companies, it's going to be an operating agreement. And so when do you need it? So there's a couple of scenarios when you need it. So the first is if you are forming your LLC in a state that has anonymity. So the two common states are Wyoming and Delaware. They both provide for anonymity. So in those states, you're filing basically a one-page document with the Secretary of State of those states. And it basically says, here is the name of the LLC. Here is the statutory agent. So this is the person that's authorized to receive service of process within the state of formation, and you have to have that. And the limited liability company is either member managed or manager managed. And that's it. That's it. And that's what you file with the state of formation in Delaware and Wyoming. Well, then that's great, but how do you know who owns the company? Because the records of the state of formation do not tell you who the owners of the company are. So in order for you to know the owners of the company, you have to have an operating agreement. And because these states offer anonymity, their statutes provide that you have to have an operating agreement. So for you to validly form a limited liability company in a state that has this anonymity, the statutes of that state require that when you form, you have a signed operating agreement that lays out the ownership of the company, the management structure of the company, and sets forth everything that the company needs as far as its operations. That's not the same in Arizona, for example, where we don't have anonymity. So when you form in Arizona, you file and you specify in Arizona who the owners of the company are, meaning the members, and you specify that. And by default, it's percentage based upon the number of members. So if you have 2 members, each is going to own 50% of the company. If you have 3 members, each is going to own 1/3. Or if it's just 1 member, then that member owns 100% of the company by default. And then you specify who the managers are. And if it's a manager managed LLC. And so you then identify here are the managers. And our statutes in Arizona provide that the managers have certain powers, duties, and obligations. You don't need an operating agreement to explain that. So in Arizona, for example, if I go and form an LLC and I'm the only member of the LLC and I'm the only manager, if it's a manager managed LLC, In that case, I don't need an operating agreement because the statutes dictate everything from ownership to management and operations. The statutes basically become the operating agreement. I don't need to, go through the process of having this other document out there. Nor is it needed for asset protection. We have cases in Arizona that say, hey, you don't have to have an operating agreement in order to create the corporate veil and to protect the limited liability company from having the corporate veil pierced. So you don't need it in that case. However, let's say that you have 3 members, but 2 of the members are going to own 40% and the other third member is going to only be 20%. Well, then in that case, you're definitely going to want an operating agreement because you're going to want to specify that different ownership percentage versus when you file with the Corporation Commission. Like I said before, the default is 1/3. So if you don't have an operating agreement and you file the articles of organization, then the presumption is everybody owns 1/3. You have to have that separate operating agreement that states otherwise. So that's the situation or the scenario where you're generally going to want to have an operating agreement. Or let's say that you have 2 members, 2 owners of the LLC, but you have capital contributions that one member is making, and the expectation is that there's going to be an event that's going to happen. For example, the sale of real estate. So, let's say this LLC owns 3 pieces of real estate, and you have one member that's put in capital to purchase, each of those properties. So, every time a property is purchased, you have a member that comes in and puts in capital for that. And you want to make sure that if you sell one of those pieces of real estate, that member who put in the capital for that specific purchase, that they receive their money back. In that case, you're going to want to have an operating agreement that specifies when that capital is going to be returned, because otherwise, by statute, the capital is just returned upon dissolution or agreement of the members. So you're going to want to have an operating agreement that specifies the early return of capital. So that's when you need an operating agreement. And those are the scenarios that really an operating agreement comes into play.
I've seen situations, I'm curious to see whether you've seen the same. Obviously, you don't, in Arizona, and you mentioned this, you don't technically need an operating agreement if you're by yourself. You can rely on the statutory scheme that is presented and that is there. But I've seen situations where, lenders just don't care. In fact, I'll get the call from the client and they'll be like, well, this lender, they want an operating agreement. I'm like, well, you're the only owner of the LLC. They're like, that's what I told them. They don't care. So we did an operating agreement. So there might be situations, and maybe you've seen this, where even with a single person, third parties, in order to have something to rely on, are going to require it.
Yeah, that's exactly right. So there's what the law provides and what a lender is willing to do as far as a lending perspective, and they may not always be the same thing. So you can have what the law states, which is you don't need an operating agreement if it's just a single member LLC in Arizona. But lenders may not be comfortable. And the reason is because a lot of times lenders are working in more states than just Arizona, right? So their underwriting guidelines are nationwide. And so they're looking at states like Wyoming and Delaware, which say you have to have an operating agreement by law. And because you have to have an operating agreement by law, then they're going to make that part of their underwriting process, because they don't want to have to create a table of all 50 states and figure out which states they need an operating agreement, which states they don't need an operating agreement, that type of thing. So, the lenders and title companies even. I've seen title companies that have that same requirement where they say, no, we need the operating agreement. You're like, no, you don't, because it's a member managed Arizona LLC. No, we need it. So, okay, we'll put one together, quickly here and get it over to them. But yeah, you're right. For purposes of real estate transactions, even though Arizona, you don't technically need one, you may be required by either the title company or the lender.
Good stuff. Yeah. So it might be a good practice even to consider doing on right at the outset when you first establish and form your limited liability company, just to have that ready and waiting, given the fact that if it's just you as the owner, that's not going to take a ton of time for an attorney to prepare. So maybe something that would be a good practice to have. With that, let's get into our topic today. And today we are talking about adverse possession claims and adverse possession generally. And this is an important topic for the real estate investor because really it goes to what is it that you're buying? And are you buying what you think that you're buying? Or is there some adverse claim by somebody else, whether it be small or large, as to that property that's going to impair or get in the way of what you thought you were buying? So to discuss that topic today, we have attorney Jeff Johnson from the state of Georgia, who is joining us to discuss adverse possession. Jeff is a senior associate with Fowler St. Clair, and he's in Fowler St. Clair's Georgia offices. Jeff, thanks so much for joining us.
Thanks for having me.
So give our listeners an idea. You're an attorney in Georgia, but give us an idea. Where are you licensed to practice law currently?
I'm licensed in Georgia and South Carolina, and my background is civil litigation, and I have a variety of civil litigation experience, both criminal and civil within the civil context, real estate litigation, commercial contract litigation, personal injury, and other forms of civil law.
All right. So today, we're talking about adverse possession, and adverse possession is one of those things that we learned about in law school. It has certain elements, and we'll talk about that. And there's a lot of similarities from state to state on adverse possession, but there's some differences as well. But let's just start from the beginning here for the casual real estate investor who's really just getting into this and trying to understand the pitfalls out there for them. What is adverse possession?
Adverse possession is where somebody can get title to real estate and become an actual owner of real estate in the eyes of the law without having purchased that property and titled it in his or her own name. In other words, it means that they take possession of the property and they're on it or in it for long enough, according to that state's laws, that they will be recognized as the rightful owner to that house or to that piece of land.
Yeah, I think when people first hear that the first time, I think it's like kind of like a punch to the gut. It's like, somebody who didn't buy this property can come in and claim ownership to it. And I think history probably gives some perspective. My understanding, and correct me if I'm wrong, Sean or Jeff, my understanding is that it's just the old kind of historical idea that he who works the land essentially ought to be entitled to the land. And this idea that somebody who can work it, take it, and if you're not doing anything with it, and they're not doing it in some sort of like secretive way that you don't know about, then they ought to be given right to it. But for the real estate investor out there, this is, a real problem, and we'll get into this. Oftentimes you don't even find out somebody has a claim to this until you've already bought the property. So given that that's the definition of adverse possession, what kind of forms can adverse possession take? Obviously, the obvious form is I'm making a claim to your entire property, but does it have to be to the entire property?
It doesn't have to be to the entire property. It can be just one border of the property or one portion of it. And the way it comes up often is with something like a fence or a wall, where you've built a fence and it's 10 feet over your neighbor's property line. And through adverse possession, you could acquire that strip of land that is portioned off by the fence, or it could be where you're using a portion of your neighbor's land to park vehicles or equipment, or you've placed a garden there, you've placed part of a swimming pool or something like that there. It doesn't have to be the entire property.
Interesting. Where I've seen this a lot is roadways, where or driveways. The driveways getting into the property, where they're using it. So, what has to take place in order for a party who's making a claim for adverse possession? And I guess this is legally an elements question. What generally has to take place in order to have a successful claim for adverse possession? What does that look like?
Okay, so when I was in law school, my property professor was a guy named Maury Osborne, uh, big real estate guy out of Florida, and he came up with an acronym that's a little bit corny, but it stuck with me for over 15 years to help me remember everything that has to come together for an adverse possession claim. And so his acronym is HONEY because he said adverse possession is a honey of the deal. All right. And so the H stands for hostile. You have to make a claim of right that is hostile to the true owner's claim on the property. We can talk more about that if you want. So it's got to be hostile. It's got to be O, open, N, notorious. In other words, this has to be some sort of visible appropriation of the property. You can't just in your mind decide, I own that. You have to have an open and notorious use of it. E stands for exclusive. That means you have to be using it the way that a true owner would. It's not something where you share possession of it with the true owner or you're there by permission. It has to be exclusive. And then the Y is the one where Professor Osborne made a little bit of a stretch as far as the acronym is concerned. That element is continuous. It has to be continuous possession of the property for the statutory period, which varies by state. So the way he came up with Y is yada, 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 which means it has to go on and on and on for whatever the number of years that your state requires. So hostile, open and notorious, exclusive, and continuous, yada, yada, yada.
Jeff, I want to jump back on the hostile element. So when you state hostile, I think that also means adverse, like, you're not allowed to be using this property or you haven't been given approval. What's something that, say, an owner could do should they discover that somebody's, let's say they've built a fence, right? The neighbor has built the fence onto their property, like you said, 10 feet. It's been there a few years. They just discovered it, but it's not a big deal because they're like, am I going to fight with this neighbor and spend, tens of thousands of dollars in attorney's fees over the fact that, the fence line is there. It looks fine. I'm not going to be using that, 10 feet strip of my property anyway. Not a big deal, but I don't want to lose my property, right? You don't want to lose those 10 feet. Is there something that they could do to make it so that the possession is not hostile?
Sure. And the term hostile or adverse, as it's used in the law, doesn't mean hostile in the way that we often think of that word. It doesn't mean that there's ill will between the neighbors or some sort of animus or malice on the part of the person who's taking over the land. It just means that they're using the land under a claim of right. They're using the land in a way that says, this is my property and I'm claiming it as my property. By building a fence or a wall or a driveway, that might be one way that they could otherwise establish that element. So if you're the one who truly owns the property, you have title to it, your neighbor's built a fence or a driveway or whatever it is, what can you do to keep it from becoming hostile? There are a couple of things that you could do. One way is to officially grant permission to that person to use the property in that way, because if they're using it with your permission, then it's no longer hostile. All right. So sometimes people are worried, well, if I give somebody permission to come onto my land and they do it for long enough, will it become their land? The answer is no, if they're doing it with your permission, which can be explicit or implied. The safest way is to make it explicit permission, which could come in the form of sending a certified letter to that person saying, look, you built this fence or driveway on my property. You should know that it extends onto my property for such and such feet. I'm hereby giving you revocable permission to use the property in this way, which can be withdrawn by me at any time, etc. So that would be one way. another way, and that's what you would do if you are okay with the use and you don't mind the fence being there, you don't mind the driveway being there, but you want to establish on record that this is with my permission.
So that sounds all well and good, but you do some personal injury work, right?
Yes.
So I can imagine a scenario where, okay, I give them a license to, use and enjoy that property. However, what happens when one of their kids decides that it's going to be fun to play on top of the masonry wall that technically is on my property, and then somehow they manage to fall off that wall and seriously injure themselves,
Or the wall fell on them.
or the wall falls on them or something, right? Or the wall, it maybe it wasn't built as well as it should, and somehow it falls over, and all of a sudden now, who's going to get sued?
The short answer to that is probably anybody and everybody that has anything to do with the wall, which would
Right.
include the possessor who built the wall, as well as the owner who allowed the wall to be built and presumably has knowledge that not only it's there, but maybe they have knowledge or should have knowledge that it's not in a safe condition. So that's certainly something you want to think about, depending on what type of structure it is that's impeding on your property. Is it a driveway? Is it a rickety fence? Is it a ramshackle wall? Is it, dangerous equipment or some other hazard that might be there? So those are things that you certainly want to take into consideration into whether, number one, is this something that I want to have torn down or order them to have torn down, or is it something that I'm okay with having on my property? You do need to think about those potential liability issues that are out there. Consult an attorney, see if there's some kind of waiver that could be signed, but even those are not ironclad and will not prevent you from being sued. Whether they would hold up is going to depend on the particular agreement and the other circumstances of the case. But it's certainly a relevant issue and one that you need to keep in mind.
Well, Sean, the where I've seen this come up, and this would probably, for a real estate investor, would be the reason why you might do one step further than just sending out a letter saying, I grant you permission, because the permission's important in order to defeat the adverse possession claim. And I think what we would probably find in most states that in and of itself is sufficient to defeat the hostileness, or that element, hostility. But that doesn't solve those other problems. And where I saw this come up and was involved in a matter was they wanted the license issue or the permission slip to be documented in a license agreement. And the reason for that was there were provisions that were negotiated, but essentially dealt with insurance of the wall. Who was going to insure the wall, how it was going to be insured. In this case, the client had built a wall on the other person's property, and that person happened to like that wall for a period of time. But to the same issue, his lawyer said, well, what about, if this wall falls and hurts somebody? How we want to make sure this is insured, that we're added to the policy and all those kind of things. So one example of why this might require steps beyond just the permission slip, and why it probably serves everybody's interest, both sides, to establish that in whatever agreement that might be put in place in the form of a license agreement. So that's the hostility element. What the acronym again was HONEY, right? So what was the open and notorious?
Open and notorious.
So getting into open and notorious, give us a rundown again what the law is worried about when it comes to whether it be open and notorious on top of being hostile.
So one of the ideas behind adverse possession is that you're using the property in a productive way. You're using it in the way that a true owner would as to that type of property. And it should be enough so that the true owner is on notice that you're there on the property, and then they have the opportunity to take whatever action they deem necessary to remove you or to give you some sort of license, as we're talking about. And it doesn't necessarily have to be that you build a structure on the property, but you have to be using it in such a way that the public or anybody else who looks at it would know that you're there. And what that is will depend on the type of property. It doesn't have to be building a house on it, but it could be if it's open land. Are you fencing it off? Are you mowing it, bushwhacking it? Are you landscaping it in any way? Are you farming it? Are you using that property for whatever type of property it is in the way that a true owner would, in a way that's open and notorious? It's visible. It's public. It's not some sort of secret use.
So this can be, the idea here is that to the buyer, or the person who owns the real estate, it should be, if you're walking the borders of your land, if you're taking part in your own land, it's something that you ought to be able to see or notice, right? It's not something that's really in secret.
Correct. Yeah, it has to be visible. Just like you said, so that if I'm the owner of that and I'm taking care of my property or paying any attention to it at all over the course of years, I'm going to know whether somebody is parking equipment on it, whether somebody is using part of it as a road or a driveway. And therefore, I have the option of ejecting that person from my property, removing the structure, whatever it is, or filing some sort of action such as ejectment or trespass.
I think this prong, I'll see what you guys think, is most often missed, not because it's missed by the current owner of the property, or maybe as a real estate investor, missed by you when you buy the property as being a potential problem. And it's not that the claim isn't open and notorious. It's that your understanding of your own boundaries are faulty. You've assumed based on where walls were when you saw it, not based on a survey of what is the actual outline legal description of the property, right? That's what delineates that. Is that what you found to be, a common cause for maybe just misunderstanding for where the property lines begin and end?
I think that's most common. Now, you do have situations where a person owns property and the property that they own is not close to where they live. They might live out of state, or they inherited this property, or they bought it for investment purposes and they just kind of have it sitting there. Or maybe they bought it for conservation purposes, but for whatever reason, they're not driving by and checking on it every few months or even every few years. Sometimes it's a situation where the person may not even be fully aware of what they own, or more commonly, though, it's a situation like you're describing where there's some confusion about where the boundary is. They don't realize that's their property until after this wall or this fence or this driveway or this house or whatever it is has been there for years and years. And then they realize, oh, that is my property. That is over the line. And then they try to have the person remove whatever it is, or they try to have the person ejected. And then now they're faced with an adverse possession claim. Sorry, I've been here long enough that to the extent there was any mistake about it, it's mine now through adverse possession, if nothing else.
Where I've seen this happen too, when you think about these elements, of course, you're initially thinking about what's on the ground, what's built on the ground, and that is an important piece. But when you learn about real property in law school, it's they draw an imaginary line up into heaven, so to speak, and all the way through the bottom of the earth. And I've seen situations where the structure itself might be in the property line, but not the roof. It overhangs, and that's something to potentially watch for. And we'll talk more about the due diligence side of things and what to watch out for. But there are other things that are above the ground that might be encroaching and that might create a claim for adverse possession. So that's open and notorious. We're now on the honey. We're now on exclusive. Is that right?
Exclusive.
Well, explain exclusive. It needs to be the exclusive, open and notorious hostile use of the person making the claim.
Yeah. So meaning that it's not like a shared occupancy thing where there's this there's this field, and the true owner uses it to graze his cattle, and sometimes my cattle get on that land too, or it's got to be where you have established it either by some physical barrier, or just in your use and taking over that property, and you're using it exclusive of anyone else, just like a true owner would. And that's really kind of the question that it comes back to with each of these elements. Am I using the property in a way that a true owner would? And so it can't be with permission. It can't be shared. It can't be, it has to be exclusive to meaning not that no one else can set foot on that property for 7, 10 years, whatever it is, according to your state, but meaning that you're claiming it as yours, not that you're sharing it with somebody else.
Jeff, on the element of exclusivity, now property is bought, sold, it's leased, things like that. Does it have to be the current owner that has exclusively, or the current individual that's exclusively utilized the property for the requisite amount of time? What I mean by that is, let's say your fence example, right? A property owner builds a fence 10 feet onto the neighbor's side. And so there's, 10 feet of property there that's being utilized by that owner's property, the owner that's going to claim adverse possession. But they've lived there for 7 years, and they decide, I'm going to sell this property, and they sell it. Somebody else comes in, uses the property in the same manner. They're still utilizing that 10 feet portion that's, where they built the fence improperly. Can they go back and piggyback on the prior owner? And if so, how does that work exactly?
That's going to depend by state. Many states do allow tacking of possession, meaning that if you've got people who are in what's called privity of ownership with one another, you could have 1 to 10 different owners, but if all of them have been in adverse possession of that property and together they satisfy the statutory period, and they can show, all right, together we all have a continuous 7, 10 years, whatever it is, then it can be tacked together. Other states say no. Once there's a change in ownership, there's a break, and then you have to start the clock again, so to speak. So you need to be familiar with your state's rules as to whether that tacking is allowed.
Oh, okay. So tacking is a state by state concept and not just a general overall adverse possession idea.
Correct.
Oh, good to know.
All right. So we've discussed open and notorious. We've discussed exclusivity. The last one we're on is the yada, 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 right? Did I get that right?
Yada, yada,
yada. All right. So that I know, a lot of what we've been talking about is really fact intensive kind of stuff. This element is too, but the yada, yada, yada requirement, the period of time or statutory period of time can change from state to state. What is the required time in Georgia?
Okay. So in Georgia, there's 2 different rules. It's either 7 or 20 years. All right. It's 7 years under color of title. And what color of title means is that you have some sort of writing that says you're the owner of the property, but for whatever reason, that writing is legally insufficient to transfer title to you. So it could be a deed, and there's some defect in the deed or in the recording of the deed, so that your legal official title to the property was never rightfully established. But you think it's your property, and you're operating under color of title, meaning that you've got a writing that says it's yours. It's defective. But if you've got that plus 7 years, then you can satisfy the continuous element of adverse possession. If you don't have a writing like that, and you have nothing to show that it's yours, you're just somebody who has taken over the property, then it's going to be 20 years. So 7 years under color of title, you've got a document, but for some reason the document's bogus or it's ineffective in some way, or 20 years you don't have any kind of document.
So in Arizona, we have 2 time limits, and the same concepts. So the first is 10 years for just general adverse possession, which is half the time of Georgia, the 20-year. But we also have the color of title, and that's 5 years, so just a couple of years less than Georgia. However, Arizona requires that the owner or the party seeking to adversely possess the property under color of title, that they actually pay the property taxes for 5 straight years. That's the requirement. So you have color of title and you pay the property taxes for the property for 5 straight years. Does Georgia have a similar property tax payment requirement for its color of title claim?
No, and that's something that's going to depend by state. There are some states that require you to have paid the property tax on that property for each of those years. There are some states where if you want the shorter period, like Arizona has, then you have to pay the property tax. And then there are other states that just have a straight period of time, and whether you pay the property or tax or not is not a factor. With Georgia, they're really looking more at do you have a deed to this property, and just the deed is defective for some reason. They're not as concerned, although that could be a factor into whether you're claiming under color of title.
Yeah, the idea of color of title really is that we're giving you this shorter time period because obviously you paid for it, you thought you owned it, you did own it, absent some, technicality. And I guess what it really provides is just another, I'm just brainstorming here, but another remedy outside of going back to maybe the title company who screwed up and maybe they're not around to fix the faulty recording or the faulty deed or whatever it is to fix it. This just gives another avenue in order to do that.
Yeah, and where we see that a lot too is inheritance, where somebody is rightfully entitled to it under the will. They try to transfer it by affidavit, which I think is allowed both in Georgia and in Arizona. You can transfer title from a decedent to the rightful heir via an affidavit, and they mess up the affidavit, or something gets messed up in the probate and it just doesn't get transferred properly. So there is no title company involved, right? But you can establish a right pursuant to, that will or statutory right to inherit or something like that.
So you've got the statutory period. You mentioned in Georgia. Did we say what the common law requirement was? 20 years, correct? I think you said that.
In Georgia, the common law period is 20.
20 years, which is a long time. But in order to bring that, and in Arizona, it's 10. So in order to bring that claim, you had to have continuously done that for the 10 years. Now that seems like a long time, but land is land, and it's been around a long time. And if there's been a structure or there's anything built on the property, and even if there's not something built on it, if there's neighbors and you've come to the table to a new property, it stands to reason that this could be an issue and something that you need to be aware of. So let's talk about, we're all real estate attorneys. Let's talk about what the real estate investors can do to protect themselves when they're purchasing the property. And we all know in all the states that, when you go to buy property, you're going to be given usually at least 30 days to close escrow on the property. Now, nobody ever seems to think about due diligence unless they're doing a commercial purchase. Due diligence is built in. Due diligence clauses and lengthy clauses are built into commercial purchase agreements, but I think oftentimes in real estate deals, it's just forgotten about. And we can get into title insurance as well, because I think a lot of people assume that title insurance might just cover me on all of this kind of stuff, and oftentimes it doesn't. But what are some of the things? Let's start with you, Jeff. What are some of the things that you'd recommend a real estate investor? They come to you in Georgia and they're considering a property, whether it's vacant land or whether it's got improvements on it, whatever the case may be. What are some things that they can do to avoid unknown claims for adverse possession that may be coming down the pipeline?
Yeah, about 5 things come to mind, and one would be, is there anybody on the property? Is the property occupied? By whom? How long have they been there? Do they have a lease? And so that would be a situation where it's a house, and you know that the house already has occupants other than the title owner of the property. You would want to know how long they've been there. What's their status? Are they family members? Are they lessees? What are the circumstances of their occupancy? Something you definitely want to talk to the owner about, and you may even want to drive by there and talk to the occupants of the house about, and see if they tell you something like, hey, we think that this is our property, and we plan on staying here regardless of whether it's bought or sold, because we think we have some kind of claim to it. So just being aware of who's on the property. Another thing would be, in looking at the property, is there stuff that's on the property that appears to have been placed there by someone else? Is there a fence or a driveway or a wall where there might be some question about where exactly it's placed, who has title to it? Is there equipment that's parked there? Is there landscaping that seems to extend from one parcel to another? Features like that. Another thing to be thinking about is access, ingress and egress to the property. Like, how are people getting onto and off of these parcels? Is there a shared driveway? Is there some sort of alleyway between two houses? And both of the occupants of the houses are using that alleyway in different ways. Who owns that? You can go on county websites and look up, potentially, depending on your county, are there aerial photos that show an overlay of both the satellite imagery of the property as well as the property line, so that you can maybe see, especially if it's a big piece of property that we're talking about, maybe you can't see all of it from the street or the road. You could look at some aerial photos. And also, if it's part of a planned community where they have CC&Rs or a declaration of covenants, you get a copy of that and look and see. And sometimes there are provisions in those CC&Rs that say, if there is a wall or something like that, and it's built within so many feet of the property line, but it extends over an adjoining property, that there's thereby a license that's granted to the builder of the wall, so that if you're the true owner of it, you've got something to fall back on and say, look, no, you've got permission to keep the wall there, but it's not going to allow you to gain adverse possession to it. So sometimes there are even provisions in the CC&Rs that will help with things like that. So it's really just about doing due diligence, like you said, and examining as many pieces of this puzzle as you can to convince yourself that there's nobody that could have a pre-existing claim to the property by adverse possession.
Well, 2 immediate things come to my mind as well. We get so wrapped up during the inspection period of the purchase to nitpick all the different inspection items. Okay, this needs to be fixed by the seller before we finalize the buy or whatever else, and we're negotiate that. But I'm thinking back of all the homes that I bought, and I can't think there's been very many times where I've walked the property line. It's something you could do during an inspection. That's not that difficult to do. The other thing, I don't know if this is the case in Georgia, but in Arizona, our aerial mapping system is pretty sophisticated. I can pull up on the Maricopa County Assessor's website. I can type in the parcel number or the property address. I can bring that up. I can look at an aerial. Now, the aerials should not be the ultimate thing to be relied on. They're not the legal description, but they're pretty darn close. And I've litigated enough adverse possession claims to know if something's protruding by a few feet, it's usually going to pick that up in an aerial. It's going to do that as well. And so that's another area I think that owners or potentially future owners can conduct due diligence on to determine whether there's any sorts of open and obvious issues relating to the property. One other interesting thing I don't think anybody thinks about, everybody's always worried about any claim as to their own property. But what about when you walk the property line and it seems pretty clear that the person you're buying it from has an adverse possession claim against the other owner? That would be really good to know, I think. One, I would want to know, okay, where are you at in the statutory period of time? Two, if I'm not there, am I going to be running into an issue with my neighbor where they're going to conduct, and we'll talk about this, some sort of self-help remedy by removing or making me tear down a structure that is built on the property that I've built and is now protruding on the other property. Another area I think you want to do due diligence on.
You might want to think about having a survey done too. And usually surveys are not super expensive. You can have one done for several $100s, and nobody wants added expense. But if you're really looking for peace of mind as to where the property lines are, if there's any question about it at all, a survey might be a good idea.
So this is an interesting issue. What happens if you actually end up building on an easement that is dedicated or reserved to the municipal government where the property sits, right? To the city or the county or the town, and you end up building on it? Because a lot of times you dedicate the easements, but the city, in areas that aren't fully developed, they're waiting till there's more houses and things like that before they're going to install the roads. And so you don't exactly know where the line is, and you end up building on there. And let's say 10 years goes by, what then? Jeff, can you adversely possess property or a property right of a municipal government?
The rules, as far as that is concerned, are going to be a lot trickier. Generally, governments build in protection for themselves against things like that. That's something that you would want to look at a state by state basis. I know with utility companies, like here in Georgia, I know that there's I won't say it's a famous case, but in terms of adverse possession, it's an important case where the you can claim adverse possession against a utility company, or vice versa. A utility company could claim adverse possession against the homeowner. But in terms of municipalities or state governments, I don't know that there's an easy answer to that.
Yeah, and I do think it may be a state by state thing. Where I've seen this in Arizona, are in federal patent easements. So here it's not uncommon in like county islands where it's outside of the city and it's just in the county, and you'll see in these kind of rural areas with large open desert lots, you'll see, if you were to look at an aerial, you'd see like these roadways, and they kind of they don't go anywhere. Sometimes they go somewhere, other times they don't. And some of them were federal patent easements that were created as like a potential road when development was moving westward expansion kind of thing. And they had these roads. Now there's a process to remove a federal patent easement. The homeowners can go, it's like, I've got this roadway going along the side of my property and nobody ever uses it. There's the way to go to the county and ultimately get that removed. But I've seen issues in adverse possession claims where a driveway sat over a federal patent easement. And I'm pretty sure there's case law that says that you can establish an easement over basically a federal easement is what it is. So, I mean, that's a good point. That can certainly be an issue and something to watch out for. So let's talk about remedies that the owner has at their disposal should this come up. And let's talk about it from the perspective of the person who's making a claim for adverse possession, because the law says that I've adversely possessed the property, assuming I meet the elements, but the title work doesn't say that, right? The deed doesn't say that. The legal description on the deed says this other owner has all of this. So what can I do if I'm the homeowner that's wanting to exercise and pursue a claim for adverse possession, or what would they do in Georgia at least?
I think what you would want to do is, and how this is named can vary, but you want to get a judgment from the court of that county, or whatever court has jurisdiction over this property, with a declaratory judgment or order quieting title establishing that you've satisfied the elements of adverse possession, and that the property is now going to be titled in your name. And so that way, if for whatever reason you have to establish that you now have title to the property, either because you want to sell it or because you want to have it encumbered in some way, going through the legal process of filing in court and getting a court to establish, yes, you've established all these elements.
That's pretty similar to here in Arizona. Sean, why don't you explain what we typically go through to have to bring that kind of cause of action here?
Yeah. So the first step in Arizona would be to determine whether or not you want to cover attorney's fees or recover attorney's fees as part of the cause of action. So here in Arizona, before you bring a quiet title action, you have to send out a notice 20 days in advance of filing the lawsuit for quiet title. And in that notice, you basically say, hey, I'm adversely possessing this portion of your property, or I'm adversely possessing the whole of your property. And instead of me filing a lawsuit to quiet the title, I want you just to deed the property over to me. So you send the letter out and you say, here's a quitclaim deed, execute the quitclaim deed, and here's $5 for, and I think it's it's an archaic or an old statute, so $5 for your trouble. Here's the consideration, $5 consideration. Here's $5. Execute the quitclaim deed, send it back to me. And if you do that within 20 days, I'm not going to sue you. And most of the time, 99% of the time, we never receive those back. I have seen it where it's happened in a couple of occasions where, either my clients executed it and sent it back, or the other side's executed and send it back for one reason or the other. But you execute it, you send it back, or you don't. And in that 99% of the time where it isn't sent back, then the party that's claiming adverse possession has the right to go and file a lawsuit for quiet title, and you can combine it with a declaratory judgment action like Jeff was saying. And as long as you've sent that letter, if you've done that, then you have a right to recover your attorney's fees against the party that refused to sign that quitclaim deed. Now, there are times where you're in escrow and you're just wanting to close, right? Where you're like, I don't have time to send this letter. And so if the client doesn't want to send the letter, doesn't have time, you could just file the lawsuit. But if you do that and you don't send that letter, there's, significant case law support to this here in Arizona, which is you don't recover your attorney's fees. It doesn't matter if you try to send the letter later on or do something else. You don't have a right to recover your attorney's fees. So you have to send that letter out first before you go and file that lawsuit. And if you don't, you can still prevail. You can still quiet the title. You can still receive a favorable ruling on your declaratory judgment action, but you cannot recover attorney's fees. So that's a little bit different than Georgia, where, if you want to try to recover those attorney's fees, you would send that letter out, wait your 20 days, and then file your lawsuit.
So let's talk about this from the perspective of the property owner who's being encroached upon. What are their remedies here? There's a number of them, whether it be bring an action for trespass, ejectment, including a claim for damages if those are appropriate. And then there's self-help. That's my favorite. That's the funnest one to deal with, self-help. Is the process fairly similar in Georgia?
Yeah. So if it's not something that you can resolve on your own, you can, it depends on what kind of possession it is. Obviously, if it's somebody living in a house, you have to go through the eviction proceedings, depending on how they got there and that sort of thing. If it's more so an object or a structure that's across the property line, you could deal with it in different ways. But yeah, you're looking at eviction or trespass actions to get them off the property. Or like you said, are there things that you can do on your own to get rid of whatever the offending object is, and get it off your property?
Yeah, so self-help's my favorite because the client is always shocked when that's suggested as an option. And my response always is, well, is it your property or is it not your property? If you had put up a structure on your own property, you can take down that structure. This is your property. You can do what you want with it. And the thought is, well, if somebody else did it, that would be rude, Well, yeah, it's rude, but it's rude to build it on your property. But they're always so surprised about that. Well, Jeff, we really appreciate you being on with us. Thanks so much for taking the time. If you would tell our listeners where they can find you and how they can connect with you.
Sure. If you want to shoot me an email, my email is johnson@fowlerstclair.com. I'm also on Twitter. Jeff Johnson GA is my handle. You can find me there. You can call the offices of Fowler St. Clair. That number is 480-788-9911.
All right. Well, we really appreciate it. And for those real estate investors in Georgia looking for help, Jeff Johnson is there. Keep him in mind. Feel free to connect with him. Jeff, thanks again for taking the time with us. We appreciate it. Look forward to doing it again.
Thanks, guys. It's been fun.
Thanks, Jeff.
All right. With that, everybody, that is our episode for this week. Make sure to join us next week, January 3rd. We're going to be in a new year, 2023. Can't wait to do the podcast with you and have you watching. We'll see you guys next week.
Have a good day, everyone.